Federal Rules 56B states, unless a different time is set by local rule or the court orders otherwise, a party may file a motion for summary judgment at any time until 30 days after the close of all discovery. Yes, that is the rule. And sometimes a party will file a motion for summary judgment before the discovery period commences, and sometimes before the discovery period ends. And in my experience, it's usually the defendant who files the motion for summary judgment. But it doesn't matter because the rules are going to be the same, regardless of who files the motion for summary judgment. And that's what we're going to talk about today. A party's option, and we're talking about the non-moving party, that individual's option when the moving party files a motion for summary judgment early. And we're going to look at the prerequisites that the non-moving party needs to produce to the court in order for the court to give the non-moving party the green light to continue discovery. So let's get started. Federal Rules of Civil Procedure 56F provides for a continuance to conduct additional discovery. Pursuant to the rule, a party, plaintiff, or defendant can file the 56F when he or she is faced with a motion for summary judgment and need more time for discovery. He or she can request a continuance to conduct additional discovery by showing the court through affidavit or declaration the reasons why they cannot present facts essential to justify their opposition. And I would call it a motion for continuance. And the caption of the document could look something like this: Motion and declaration under Rule 56F for extension of time to oppose summary judgment. So to prevail on the Rule 56F motion, the party must show the following: specific facts the party hopes to elicit from further discovery. 2, that the facts exist. And 3, that such facts are necessary to resist a summary judgment motion. And here, Cornelius versus Ryan Delucas, bodybuilding.com, it is a court's memorandum in order wherein the court discussed how it arrived at its decision to grant Cornelius's 56F motion. Read it. You will find it very enlightening with regards to the 56F motion and the do's and the don'ts. I wanted to come back and talk to you a little bit about due diligence. Your obligation to conduct discovery, you've got to do your due diligence. What are we talking about? You know, when the lawsuit is filed, the plaintiff needs to look out for the rules regarding meeting with the opposing counsel and with the judge. Federal Rules of Civil Procedure 26F requires that both the defendant or defendants and the plaintiff or the plaintiffs meet and discuss the case. One of the hot ticket items during the discussion is discovery. And one of the things you talk about is propounding discovery. How many interrogatories, how many admissions, how many production of documents, whether you're going to ask the court to permit you to extend the discovery period in the event that is needed. And then once the parties have met, they will reduce it to writing send it to the judge, and then there will be a 16 conference between both parties and the judge, where the judge will eventually reduce to writing what the parties agreed to. And once that reduction has been signed by the judge in order, it's called a scheduling order. That is the map. That is the parties' management map. And the parties would be required to comply with that. In that scheduling order, there will be a specific time when discovery begins and when it ends. Plaintiff, make sure that you are complying with the timeline set forth in the scheduling order, because it would be difficult for a judge to agree to allow you to continue discovery when you didn't do your due diligence. Do your due diligence. Okay? I trust this has been helpful to you. I am Advocate Lucinda, and we will see you next time. Take care.